you doing?
Hi.
Well, I'm here on behalf of the MMA. I'm a member of the MMA, and I just was really hoping that some of the rules were, especially Rule 21, were overlooked. I don't really have a lot to say because a lot of stuff's been covered, but I just really hope that, you know, if all these people that went out to vote, the 3 million so on people, that it seems like a lot of the stuff is really being changed, you know, from what we've looked on and what we voted on, and it'd be really fair to look at some of the people that all these people that have taken the time to show up, and make it easier for the lower income to be able to excuse me, to be able to get the medicine that they need, and I guess that's pretty much all I have to say. I really didn't have a lot prepared, but I just want to make my voice be heard that what was voted on and what is out and the changes have been made are totally different from what we voted on, and I just really hope that you know, there's a lot more knowledgeable people out there, but I just really hope that that definitely the things are looked at closely, and get some really knowledgeable people who know, you know, what's going to be best for the public and people's privacy.
Thank you. Next speaker is Reverend Stephen V. Thompson.
Good morning, and thank you for the opportunity to speak here this morning. I am Reverend Stephen B. Thompson. I'm the Executive Director of OCNORML, National Organization for Reform Marijuana Laws. I come to you this morning, though, as a medical marijuana patient. I've been a responsible adult cannabis consumer 42 years of my life. I use medical marijuana for chronic back pain and for bad eyes. I was predicted that I would be blind by the time I hit 40. I am 61 years of age. I also would like for you to meet my mother, Helen Thompson, who was killed by the FDA-approved drug Premarin on December 1st of 2008. She also was a medical marijuana patient for almost 10 years of the last of her life. She also had the distinct privilege at 82 of being the oldest living member of OCNORML and National. She consumed her medicine by edibles and ointments and salves for rheumatoid arthritis. You asked that we address specific rules, and I think the good folks of Michigan, of the newly formed Michigan Medical Marijuana Association, have covered those quite good, along with Ms. O'Keefe of MPP. So I picked out two specific ones that I have a real problem with, and that would be, excuse me just a minute here, in Rule 1, 7, Part 7, enclosed locked facility, I would like to point out to you that prescription drugs are not required to be locked in a locked medicine cabinet or closet or room in a house. That should definitely be changed to a lock on the front door of your home. I also have a problem with number 17, public place. I own 5 acres of land in Benzie County, from which I traveled from early this morning. That 5 acres is my sanctuary. I should have a right to consume my cannabis, whether I prefer to do it on my front porch, anywhere on my 5 acres, or within my home, which has no curtains or blinds to draw. I have a problem with that. Then over here in Rule 15, number 3, asking that a registered primary caregiver document everything. As long as medical marijuana is against the federal law, this is asking these people to document that they are breaking and violating federal law. That is overcumbersome and that is burdensome. So what I'm asking for this morning here is I'm pleading with you. Register the patients, register the caregivers, give them their ID cards, do away with these overcumbersome and unnecessary and maybe some even illegally rules, And if my mother could be here today, she would tell you the same thing. Do the right and compassionate thing by these patients and caregivers that the people of Michigan have decided to see that they have protection, and do the compassionate thing and give them their medicine without fear of arrest. Thank you.
Thank you. Our next speaker is Bill McMaster.
He's out right now. He'll be right back.
Okay.
Here he is. You're up.
Thank you. I'm Bill McMaster. I'm state chairman of Taxpayers United Michigan Foundation. I'm here to speak on 3 parts of this proposed rule list. And the first one, I think somebody made a typographical error, incidentally, aside from everything else. And that typographical error is the simple spelling of marijuana. There isn't
I'm
any.
going to stop you right there. It's actually it's based on the legislation, and so that's why it's spelled with the H. I mean, there's an O spelling, so that's why it wasn't an error. Just wanted to let you know.
Well, it is an error. There's no such word in the dictionary. You've made a mistake by putting an H where the J should go.
Okay, thanks, Mr. McMaster. Go ahead and tell us the rest of your concerns.
It's a shame that we want to perpetuate what is obviously a typographical error in the enforcement of a law that is supposed to cover a topic that isn't even listed in a dictionary. Well, I'm concerned about the $100 fee regarding the Regulation 333.111, number 1. The fee is a tax. The ballot proposal did not attempt to circumvent the state constitution. The state constitution says no new tax or fee without a vote of the people. That $100 fee is not only excessive, we think it's illegal. So we think that as you proceed, you shouldn't consider it a pot of gold for the state of Michigan to exploit sick people and to then require them for 14 days for administrative bureaucracy to take place. We also are concerned about the Rule 1, number 4, under definitions, where it says conviction. A criminal conviction by a judge or a jury, criminal. It does not further specify which court, and I would expect that if it's a felony and it's a criminal conviction, that you're talking about a circuit court. Well, we think that the wholesale arrest of people for violations of this law, or at least the perceived violations of this law, and to then make them subject to these most severe of penalties, a felony, is certainly beyond what the people expected when this law was adopted. Remember that it's a citizen initiative, not a constitutional amendment. A citizen initiative is a law, and that still is subject to the overall umbrella control of the state constitution and the Headley Amendment. That Headley Amendment, its formal name is 1978 Headley Tax Limitation Amendment. We're concerned further about false arrest. The state police trooper who spoke earlier said there's likely going to be false arrests, and that's an understatement. The law enforcement community, if you call it that, is opposed to this and has had numerous newspaper stories of how they're going to crack down and attempt to enforce to the letter. But in order to do that, there are going to be violations of people's constitutional rights. They should have recourse against false arrest. That recourse is already inherent in other state laws, such as the Michigan Open Meetings Act, the Michigan Freedom of Information Act, as well as the Headley Amendment itself. So in the Headley Amendment, it permits any citizen of the state of Michigan to bring an action against the violating unit of government if that case prevails. And the court can award and must award, under the Constitution, all costs for that person to have brought that case. Now, under the Michigan Freedom of Information Act and the Open Meetings Act of 1976, both of them, a citizen bringing an action is entitled to bring it without attorney in the circuit court, and if they prevail, they're entitled to not less than $500. It seems to us logical that if there is a false arrest, and these can be wholesale, where police officers on the street or anywhere can be arresting people without recourse to be indemnified. And we don't think that's right. We think that there should be a stopgap, a control over the police power to arrest people, charge them, and make them go through a circuit court case and what have you. The last thing that I'd like to say is that it is public record. As you're compiling, even HIPAA, that is under your control, to some degree has penalties for invasion of privacy regarding medical. And why should this be an exception to HIPAA, since medical marijuana is a medicine? So we recognize that under the Michigan Freedom of Information Act, it is a public record, and you're asking for much too much information as an invasion of privacy to risk a person being damaged, career, business, community, forever by such a registration. The LEAN, the Law Enforcement Information Network that he mentioned, is of some use, of course, but we all know that it's like a sieve. Certainly, when you answer a parking ticket in a district court or a circuit court, they have your lien record, your driving record, what have you, through the lien. There should not be, in our judgment, a taint put on that person who would be accused, correctly so, of being a medical marijuana user in front of a judge or jury. So for those reasons, we hope that you use a sharp pencil when you get back to finalizing these and take into consideration our concerns of taxpayers throughout the state. And I think the bill itself, the citizen initiative, passed by either 58% or 63%. I can't remember exactly which, but it was in the landslide area if it was in the 60s. So we hope that you don't take from or steal the consideration that people have for thinking it is sensible in this day and age for people to utilize medical marijuana if they feel they should. Thank you.
Thank you. Our next speaker is Matt King.
Hello, my name is Matthew Fink. I'm from Dexter, Michigan. As of December 4th, I got my medical script. But then found out about all these rules or whatever. I've been taking narcotics prescribed from doctors since 3rd grade. Adderall, Ativan, Xanax, everything. And those are all more dangerous, you know, most of this stuff's been covered, but it's like, I don't take the same amount of Xanax or Ativan as the next person, or whatever. And, you know, like putting limits on, you know, 2.5 ounces and 12 plants. Well, what if I want to have 12 different strains? I mean, there's like, I don't even know how many strains there's out there. And each strain helps differently with each effect. I feel like kind of insulted, because it's like, you're telling us, oh, we can do this, but, you know, you gotta hide around the corner when you do it, you know. Can't go in public where, you know, it's not, it's just, you know, it's like, feels like being spit on, I guess you could say. It's like, you know, we all know more about growing pot and the benefits than anybody that works for the government. But, and you guys are acting like, I know the law is given, but acting like you control it. You know, you're like, you have the seeds, and, you know, you're gonna just give us a couple and be like, all right, you know, like in high school or something, like, well, we'll give you this, but you can only take that. I mean, I smoke when I need to smoke, if I'm sick or whatever. So, I mean, if I have to go somewhere and I'm in a public situation, what am I supposed to do? I have to drive home, go back to my house, to smoke? You know, maybe speeding? That wouldn't be a good idea. I mean, I never looked at the laws, because the rules with it, because you're putting rules on medicine or whatever. I mean, the doctor is saying, hey, here, you know, why can't we just get our cards and leave us be? It's basically it, you know. I feel like it's, you know, you're giving us the script or whatever, but it's like we're on probation, you know. Like, you gotta check in, you know, one slip up, and everything's gone. Yeah. I mean, if my doctor asked me to record my medicine or anything, of like, you know, exactly, you know, how many this and that, or if I dropped or whatever, I couldn't do it. But that's pretty much all I gotta say. Yeah. Thank you.
Thank you. The next speaker is Matthew Taylor.
Hi, thank you. I have a short statement today. I believe Michigan has an opportunity to serve as a model to the nation as a whole and to other states on how to safely make medical marijuana available to ailing patients. And we shouldn't throw this opportunity away. As a law-abiding citizen interested in becoming a caretaker, I would like to remind everyone here today that if the regulations aren't made in a way that benefits and protects all parties involved, that's an invitation for abuse of the law, as Mr. Higgins has told us, and that would make a laughingstock of the whole thing, which I would like to avoid. Therefore, rather than spending taxpayer money on supervisory agencies or acquiring a written inventory as per Regulation 33315 Part 3 states, which is against the Fifth Amendment anyways, it seems more intelligent and cost-effective to concentrate on vetting qualifying caretakers who know their craft and letting them proceed unmolested until or unless it can be proven that they are making a nuisance of themselves or committing other crimes. I think that would benefit Michigan as a whole. I think it would benefit the patients, the caretakers, and especially the taxpayers. Thank you.
Our next speaker is Alex Mark. Merrick.
Thank you. This pertains to Rule 27, I guess Part C, which just states any incidental amounts of seed, stalks, and unusable roots. And I would like to suggest that it includes immature plants under that designation. That way, if somebody who was growing legally these plants had 12 plants, they might also have a certain number of immature plants, whether derived through cuttings or seeds, in the background growing. And I would also suggest that maybe some limitation on what an immature plant is be defined. Let's say under 6 inches, or a time designation of how long this plant has existed. In this way, you can avoid people breaking the law inadvertently. It's my opinion. Thank you.
Thank you.
Okay.
We have several individuals that have reserved the right to speak, so I'm going to go through the list and give those individuals an opportunity to speak if they want to today. The first would be Michael Shaw. Next individual would be Rudy Alsner.
Yes, just quickly. Rudy Alsner, Lansing, Michigan. What's your name, young lady?
My name is Amy Shaw.
I give you kudos and feathers in your cap for taking on this role. And the rest of you folks that have been taking your time and efforts to write these rules, frankly, you should throw them all out. But specifically, the one where they state that a caregiver's got to give a primary caregiver's name before a primary caregiver can get a license. I don't see any separation between primary caregiver and a patient. I myself am lucky, I'll be a patient, plus I'll be able to be a primary caregiver. But if you're a person that doesn't use marijuana and you want to grow marijuana for economic reasons, then it's not stated in there, in my opinion. And the next one is the rule about only 5 patients. I don't know of any other organization you have working for the state of Michigan that only regulates 5 patients. If you're a person that goes and helps handicapped people take a shower every day, you're not only allowed, as many patients as your business is capable of taking care of. So I don't understand the rule of 5 people only.
Actually, that came from the legislation, sir.
Okay, then I stand corrected, and I appreciate your knowledge of that. And have a great day, and good luck with all this.
Thank you. The next individual that has reserved the right to speak today is James Cummings. Next person is Charles Van Landenheim. Chris Brunette.
He's coming up.
Okay.
Yeah. Okay. I'd like to thank you for taking the time to hear us. My name is Charlie Van Landingham, and this is Christopher Burnett. Christopher Burnett has become a member of my family. I've been a caregiver for Christopher, not for medical marijuana, but just as a caregiver. He has a permanent disability he's had most of his life. Medical marijuana is going to be able to offer him certain regresses or means to address some of his issues. But one of my concerns is he asked me, now I'm not necessarily a marijuana person, but I am his provider. He has certain physical limited disabilities that precludes him from being able to grow things, reach things. He does get around fairly well himself. I mean, he speaks very well for himself. I'm not here to take the thunder away from Christopher, but my concerns are as a caregiver. I've got a couple issues I'd like to address under the rules. Under Rule 29, Section 3, the facility registration. I didn't understand exactly where that comes in. My reasoning for that is part of what Christopher's asked me to do is he wants to be able to help individuals along his line that are physically disabled, that can't necessarily do it, that want to be able to do it, that may need some help. So where the facility registration comes in, he wants to be able to go out there and assist individuals that may be incapable of doing that. Well, how would we know as a caregiver if I'm going by to help somebody maintain their nutrients or drop off this or do that? How do I know what their licensed facilities are? What liability would I be opening myself up as assisting this person? So the facility registration, I was kind of curious where that came from because it wasn't in the amendment. It's under Rule 29, number 3. It said a card for the facilities, if I am not mistaken. That would be one of them I'd like to address. The other one was under the annual renewal. I understand the annual renewal, and I can respect that, but Christopher's disability has been a lifelong issue. This isn't something that's popped up this week, or last year even. His is not going to go away next year, the year after, or from that any foreseeable future. So, and he is, he does receive, certain issues from the government, and he will qualify for a reduced amount. But the annual renewal, I was wondering if there's a way you could either address that for people that are permanently disabled. That could be provided to you through either their doctors or whatever, stipulating that this is a permanent disability. Is there a form that they could possibly fill out, or a different form application that may, put them in a different category where they don't necessarily have to every year? Christopher's issue is going to be mobility. He's not going to be as easily to be able to do that. Not to say it's impossible, but it would make it easier for an individual in his position. A lot of the other questions, most everybody else has addressed. In particular, I'd like to say Mr. Greg Francisco from the Michigan Medical Marijuana Association. I think he's done a fine job in addressing a number of these issues. Organizations like that and individuals like that have taken the time and the knowledge to gain, I think, would probably be helpful in possible future hearings to address some of these issues. Not necessarily something that you would have to do on such a grand scale. You could invite a smaller representative of the population, or to address some of these issues. One of those I think should also be addressed would be co-ops. I know in a number of other states, I'm not an expert in these areas. I've just started reading up on this since this has been brought to my attention as of recently. But there are other states, California in particular I know, that have certain aspects or guidelines in reference to co-ops. Now, what do I mean by there? Well, I myself are individuals that have limited mobility, like for Christopher. He'd like to learn to do some of that himself. Well, how would he be able to do that? If there was a facility or a co-op or a means that we could license or acknowledge a place for these individuals to go that would meet the guidelines, the privacy issues. They don't want to necessarily be paraded out in public, over the medical marijuana. They don't want to be stigmatized for what they're trying to do to help themselves. So I think there should be something in the rules to address co-ops. I'm not the expert to take that. Go ahead.
I just have a question for clarity, so I'm sure that I understand your comment. Are you suggesting co-ops in terms of a way for people to go and learn how to grow, how to take care of it, or a place for people to go and get it?
Actually, after hearing the state police officer speak, he brought about, he does not want to deal with all this, okay? Where would you take that? If you formed co-ops, they could be county, townships, I don't know. I'm not the expert there, but that would be a place to me where it seemed you could go, where also people that are in hospices or that, that are incapable of going, they could contact a co-op to possibly find somebody's excess that they're willing to contribute. Because that's one of the things I found. There's people out there that are willing to help others. And, that how are you going to do this? Where are these people going to gather? We're not talking criminals. Christopher, I wouldn't want to see Christopher out on some shady street trying to find somebody to get him something for his medical marijuana. You wouldn't want to have to go to a dark side of town to get your medicine. So I think a co-op should be addressed. how, like I said, I think that would be a good place for a public hearing where you could call in individuals like Mr. Francisco or any other number of individuals. I've heard attorneys here, and they're very well knowledgeable, and it, I think, could fit the guidelines. And I'd like to thank you for having the time to hear us.
Thank you. The next individual that has reserved the right to speak today is Brad Forrester. Brad Forrester. We're going to go on to the next person. We'll come back to him. The next individual is James Stewart.
Hi, my name is Jane Stewart, and I'm from Addison, Michigan. And just a brief little thing. I'm a patient, and I'm on the website for the Michigan Coalition for Compassionate Care. And I'm also a senior at Wayne State. My concern is not only losing Social Security benefits, but what about my Pell Grants and stuff if something happens? I've put a lot of years into going to school, and one little mishap could end that. So that's it. That's it. Thank you.
Thank you. Brad Forrester.
Thank you, folks. I would just like to say thank you, ladies, gentlemen, for letting us come together today and talk about all the stuff that people have questions about. And, you know, there were 3,681,020 Michiganders and us that would like to thank you for this opportunity. And the rules that have been proposed, while many do have questions, it's a start. And we at the Michigan Medical Marijuana Association feel like we can speak for many of these people because, you know, we're here to help them. We've got our website up and we get lots of interaction. We've registered over 400 subscribers. We've got 2,500 posts on over 250 questions that these people have asked. So we at the Medical Marijuana Association are just looking forward to the opportunity to get this information out to the people. We want to help the MDCH any way we can in getting this information out to people, and we look forward to you know, kind of being a partner in a sense, in that, you know, we want to go in the direction of getting everybody to fall within the rules and stay within the rules, and making the program the success that we know it can be and that we're working hard to make it be. So that's really all I had to say. Was just I wanted to thank you guys for letting us address you and listening to our comments, and we hope that you take what we've said to heart, because, you know, many of these people have traveled a long distance to come here today, and you know, they obviously have reasons, and just please listen to what they say. Take it to heart. Just make us a good system. That's all we ask. And again, I thank you for your time today.
Thank you. The next individual that's reserved the right to speak today is James Rolandhagen. Next potential speaker is Barb Hoos.
All my concerns have been answered. Thank you very much.
Okay. Melissa DePiro.
Yes.
Bob Heflin.
I'll be really brief. I'm with the Michigan Medical Marijuana Association. And when I listen to what was said here today about the rules, I'm hearing that most people have a problem with storage, reporting requirements, and the rules specifically regarding public space. These need to be addressed and changed, please. The more that we make these rules compliant, or the more people will comply when the rules are simple, when they don't threaten people, and we are dealing with patients that have a lot of stress and don't need any additional stress right now. We're hoping that we have a long and cooperative relationship with the Department of Community Health, and the rule specifically 31.1 that lists the potential for patient expansion, the list of ailments to be expanded, and the mechanism, the review panel mentions licensed physicians and 3 non-physicians. We would highly recommend that there is some form of patient representation on that panel. I think that would be extremely important. Thank you.
Next person is Robert Leonard.
I'm glad I could make it. I was born in Michigan, and I came from Florida to come to this hearing today. And I represent the Earth People's Foundation, which is incorporated in the state of Florida, although we do have offices here in Michigan. And on a personal note, I still own property in Michigan and live here approximately half the year. And anyway, I just would like to remind the committee, I may be a little older than some of the people here, that in 1936 and 1937, there was a campaign against hemp, which had been legal for the entire history of the United States of America up until 1937. And then without any sort of scientific medical study, research whatsoever, it was suddenly made illegal in 1937 by the federal government under the federal statute of the marijuana tax stamp that year. I won't go into all the details of that statute, but in effect made hemp illegal in the USA in spite of its many economic uses. It was briefly re-legalized during World War II for its traditional uses, making rope and burlap and sails and things like that, various fabrics. So it's a very useful economic plant. Medically, I'm associated with the University of Michigan departments of psychiatry. I'm not on the staff, but I am a research associate with several people there over the years. We present symposiums and seminars on topics such as the T-cell receptor, which has to do with the human immune system. Briefly, one of the active ingredients in marijuana, if you will, or cannabis sativa, happens to modulate the T-cell receptor, which allows people that have autoimmune diseases to sort of ease off of autoimmune disease. There are several things you probably heard already spoken about at this hearing, including things like MS, multiple sclerosis, and many others, where in effect the human body's own immune system, the T cells, will attack the body's own cells. And this modulation of the T cell receptor allows the body to ease off, and so it doesn't destroy itself. Just as references, I won't go into all the journals and studies, but I would refer you to Stanley Watson and Huda Akil of our department.
A specific comment regarding the proposed rules?
Yes, the proposed rules, we want to make sure allow people, as has been suggested, to use the plant in a medically specific way for specific indications that would be indicated by MDs or presumably in this state also DOs, according to the statute. And you know, we support it. We think it's time. It should never have been made illegal in the first place. And now is the time to remedy that, you know, even though it's about 70 years later. Thank you.
Thank you. I believe that's all of our speakers for today. As I stated earlier, on the notice of public hearing, the record will remain open for written comments, which can be submitted to the address listed on the notice of public hearing up until January 9th, which is this Friday at 5 p.m. So please, if you don't submit a written comment that went along with your written testimony, please go ahead and submit it by that time so that the department can go ahead and review that material when we're going ahead and taking a look at the rules. Outside of that, I think, is there anybody else who would like an opportunity to speak today? Have you filled out a sign-in card, sir?
No, I am not.
Sorry, we'll get to do that afterwards.
I just wanted to note that.
Please introduce yourself.
Oh, okay. My name is Chris Childs. I'm a student at the University of Michigan in Ann Arbor. I'm the Executive Director of Students for Sensible Drug Policies chapter at that university. And I'd just like to note that when I'm writing papers, it's usually good to revise a few times and have someone look over it again and again. I don't always do that, to be honest. But I think there should be another public hearing. I know this has been somewhat grueling to listen to everybody. There's been a lot of comments, but we've heard a lot of things. I'm not sure if everything's going to be, you know, changed the way that everyone wants, and we could have a better system if we just revised it a couple times, had at least one more public hearing. I think that would be a good idea. And that's all I have to really say.
Thank you for your comment.
I'm Dennis Hayes. I spoke earlier. I noticed and I anticipated that patients would make this point, but in California, for example, 30% of the medical marijuana use is in edibles. The regulations mention nothing about edibles, and it sure under the law as it's written, it's pretty hard to figure out what 2.5 ounces in a brownie or in a cake or something is. It could be measured. But in fact, for a lot of people with serious conditions, that's the only way they'll be able to ingest the medicine. And I think that has to be addressed. There should be something for what might be as many as 30% of the patients who can't consume marijuana in the conventional ways. Thank you.
Thank you.
Hi, my name's Mike Waller. I'm from Attica, and I didn't come prepared to say anything today. In fact, it's really disturbing talking in public. Listening to everybody talk today made me think about you guys and the fact that, as you can see, I got about half my neck now, and I don't know how long I have to live. I'm busy dying. My sister-in-law's got ovarian cancer. She won't see another Christmas, and there's a whole community of us who are dying now, and I feel like somehow we're here with our hat in hand talking to you about rules that have to do with how we die. And I'm thinking, the reality is you guys work for us. That when you're writing the laws, the rules that have the effect of law, don't they? I mean, So in effect, you're the legislator, so to speak, only you're not elected. You don't, nobody voted for you, right? You were hired and you get a paycheck like every other schmuck, so to speak. I don't mean to be disrespectful, no.
No, and I don't think that you mean that either. I think that everybody should know, though, that the bottom line is that the whole point of having the public hearing is to receive comments from the public so that we can hear what your comments are, what your concerns are, because you have to remember one thing. We're a regulatory agency, so we look at things a little bit differently than you do a lot of the time. And the thing about it is that when you provide these comments, it provides us with an opportunity to go ahead and look at it from your perspective and try to go ahead and come up with the best rules and registration program available. So I just want to assure people that if anybody's pulling a fast one or has some type of secret agenda, basically your comments are welcome because it helps us to go ahead and make the rules better.
There's a bunch of us, there's a whole bunch of us that are never going to see another Christmas. And this is not going to make it any easier for us. I'm guessing, and it really feels strange that as an American, a Michigander, I'm here with my hat in hand, figuratively, looking to die more gracefully or something. And there's something about it that doesn't feel quite right, and so try to remember that when you're doing the rules. We haven't got much time, guys, and there's one thing about the death rate. It's the same as it's always been. One each. And you're going to get one too. And when you get there, and you know you got some months left, and it doesn't feel good, you might want to think about how much trouble do you want to make it for somebody. That's all. Thank you. And keep it up.
Hi, my name is Melissa DePiero. You actually called my name. Sorry, I apologize. I decided I wanted to speak. I'm with a community assessment, referral, and education in Macomb County, and we try to prevent substance abuse with teenagers, kids. And I'm just here to just talk about Rule 27 about the locked facility. I know I don't want to go against what everybody here was saying about, I understand that it might be hard to access for patients. I mean, I'm a cancer survivor. I went through chemo. I understand what it's like to not be physically able to do things, so I understand that. But from a prevention standpoint, to have a locked facility, marijuana is a gateway drug for teenagers to do those harder drugs, the Oxycontin, the other things.
Please be respectful of her right to speak, just like everyone else has been respectful of everyone else's right here to speak.
And I'm just saying that that's what the kids start with. And I mean, I want prescription drugs to be able to be locked up. I mean, I think prescription drugs are worse than marijuana. I mean, I'm not arguing that. I'm just saying that it's just something to think about, that just to have a locked facility for, so kids, because right now the kids think it's legal. They don't understand the difference between medical marijuana and the legalization. So I was just saying, from a prevention standpoint, that to legally have, maybe just have it locked, so it's less access for the kids to be able to get to. That's all. Thank you.
Just one more comment. I'd like to second Lynn Allen from Williamston. I'd like to second what the gentleman said and request that you facilitate the implementation of the rules, speed it up as much as possible, because there are people out there who want to be law-abiding and yet are suffering. And to wait until April can be a real hardship. So I just ask that the registration process be expedited as quickly as possible for those that really need it. Thank you.
Thank you. Any other comments that were received at this point in time? I would ask that those comments be strictly restricted to the rules and the rules alone. So
I would just like to add that.
Your name, sir?
My name is Alex Mark. Thank you for being here. That some manner of provision might be suggested to deal with people who, let's say, have come down with cancer and really don't have long to live, but might find themselves in a position where they'll want to use medical marijuana, and that some provision that allows them access to it, be added. Because obviously, if a person is 6 months to live, and has to contact somebody to potentially provide the substance to them, the plants will not even be mature in some cases by the time they're maybe in intractable pain. I don't know what the solution is, how to provide it, but I'd like to suggest that it be addressed. Thank you.
Good morning. My name is Matthew Abel. I'm a criminal defense attorney in private practice in Detroit, Michigan, and most of my practice is marijuana cases. And one of the questions that is not cleared up for me in these rules is if a person can be a caregiver for 5 patients and that person is a patient themselves, does that mean they can grow for 6 people? Or can they only grow for 4 others plus themselves for a total of 5? This says that a registered primary caregiver, this is Rule 15, 333.115, sub 1. The department shall issue a registry identification card to the primary caregiver, if any, who's named in the application. A registered primary caregiver may assist not more than 5 qualifying patients. It's not clear to me whether that means 5 in addition to the person if they are a patient themselves or not. I don't have an answer to that, but when people ask me the legal question, I'd like to be able to give them a clear answer. My other comment is that because of the comments that you've heard today, it's fairly obvious that these rules need some extensive review. There aren't just a couple of minor points that need to be clarified. There are several points that need to be entirely rewritten, and I would just urge this body to publish the revised rules for comment before they're implemented so that they can be subject to further review and further public hearing if you find that's appropriate. Thank you very much.
One comment on rule number 3.
Your name again?
Richard Clement, and the Capacity Care Commission. I think that this should be done in every county, through every Department of Public Health office, manpower group. We're going to be distribution offices in every county.
Thank you for your comment. We're going to go ahead and we're going to close out the public hearing today at 11:44 a.m. And like I said, please submit your written statements or testimony by the deadline on Friday, January 9th. Thank you.